This podcast is entertainment, not financial, tax, or legal advice. Views expressed represent statements of the speaker in their individual capacity, do not represent the views of Unchained, and should not be considered investment advice. Speakers often have personal, family, or business connections to Unchained, which may include direct financial benefits. Please see our disclosure at unchained.com/podcast.
We are living through a pivotal moment. Lawmakers are drafting the rules that will define what financial freedom means in the digital age, legislation that could shape the rights of Americans for generations to come. The Last Free Americans examines this moment through the lens of Bitcoin self-custody, the intersection of law, technology, and human sovereignty. This series explores the precedents and pressures shaping this new frontier. Here's our conversation. I really hope you enjoy it.
But to get into it, I'd love to hear just sort of your background, personally, professionally, up to, I think I saw from LinkedIn, like you maybe joined Coin Center in 2014. So what was your previous life before that? What were you doing? And then what spelled your entry into this space?
So before I decided to go to law school, and actually before I was even doing undergrad college, which I did in economics, I was a working actor in New York City for 3 years. So it's my flair for the dramatic. It's come in handy with like Senate testimony and things like that. But the way I paid the bills, because being an actor in New York City, unless you're very lucky, is not a good economic choice, was designing websites for friends who wanted like their headshots up and stuff like that. And I just always really enjoyed computers and the internet. And so when I finally decided to go and get a quote unquote real job, I thought like, all right, well, I'm good at talking. I care passionately about the internet. So I want to go into like economics and law in order to defend the open internet. And like my heroes at the time were like the OG cypherpunks, like the Nick Szabos, the Eric Hughes.
How did they radar? Like, what was it like? Where you saw a blog post or you saw a forum post?
It was probably the Electronic Frontier Foundation. So John Perry Barlow, co-songwriter for the Grateful Dead, but also founding board member of the EFF. Famous frontiersman type libertarian.
Yeah.
And I think the name Electronic Frontier Foundation actually might have been his invention. This notion that as we build these new technological systems, we're opening up spaces of freedom and liberty by default, just like the open West was this place of experimentation, place of danger and need for caution, but also a place to just try different ways of organizing our lives. So that was always inspiring to me. And I always thought that like I missed the crypto wars, right? Because if you look back at the work that the EFF did, for example, in the late 90s, early 2000s, when I was still in high school, it was all around like the Clipper chip and the US government's attempt to ban strong encryption, or force people to run like hamstrung encryption chips. Or it was about the Digital Millennium Copyright Act and how, we need to have a safe harbor, a notice and takedown safe harbor, so that you can still run a server and you're not going to be liable for all the things that users do on your server for copyright violations. Communications Decency Act, a lot of stuff that Senator Ron Wyden was really big on back then. He's another hero of mine. He's still working in this space, which is cool. He's still in Congress. And I thought like, well, it's too late for me to like fight those battles. Shoot. And then I read about Bitcoin. I think it was like 2011, 2012. I didn't take it seriously enough, because if I'd taken it more seriously, I probably would have like started mining. But instead I was like, I'm going to write a paper for law school about it. So I did, and I tweeted about it a lot, and that got the attention of Jerry Brito, who was
the paper about?
It was actually about, it was for a class in compliance, but the professor was like interested in Bitcoin, which was cool. And just like new blockchain tech, possibly for compliance purposes, like corporate compliance. And so I turned it into a whole thing about like, Bitcoin as a way to organize, any kind of like group effort, like early DAO stuff, back when people would refer to Bitcoin as a DAO even.
Mm-hmm.
It was not a very good paper, but it was something interesting to me. So anyway, I think because I was tweeting about this stuff and other things, Jerry Brito, who was at the time director of the technology policy program at the Mercatus Center at George Mason, and my undergrad in econ was at George Mason, so we had a lot of mutual followers and things like that, reached out to me and said, hey, some folks have convinced me to leave Mercatus and start a Bitcoin think tank. And in 2013, 2014, that was like a crazy thing to say. And he said, congrats, I see you just graduated from law school. And I had another job lined up down in DC, but he was like, hey, do you want to be the director of research at this new Bitcoin think tank? And I was like, well, that's perfect. Because if you want to fight, or be on the front lines of the next battle for the open internet, for open technologies, open source software, working on Bitcoin policy is the best, whether or not you actually care that much about Bitcoin, and I do, but the battles that just are obviously on the horizon when you see Bitcoin emerging and becoming more of a like stable system with lots of users and viability into the long run, you think like, well, this isn't just about how copyright and privacy laws apply to communications technologies, or, export control laws apply to encryption technologies. Now this is also about financial regulation, anti-money laundering, securities regulation, commodities futures trading, banking regulations, and for all the incredibly important work that EFF has done over the years on internet freedom, they have not established a beachhead in financial regulatory matters, because until recently, there's online banking, but it's kind of like any other online service. Bitcoin and decentralized money fundamentally challenges regulatory structures, because it's not just a bank with an online presence. It's like now the online is the bank, and you don't really need the bank anymore. And that's, you get it.
Yes. So you joined in 2014 at Jerry, and then what you mentioned, kind of seeing
that's when the team got together. Like Jerry Brito, Robin Weissman, the two of them have just retired this past year, which makes me sad still to this day, because I miss seeing them in the office. They're still on our board. They're still active, but they just wanted to step away from the day-to-day, which is why I'm now the executive director of Coin Center. And we pretty quickly after that, actually, Anthony came on before me. She's our director of operations. She's incredible. She's set up so many crypto nonprofits, like good ones, not like shady Swiss entities or things like that. And Niraj Agrawal, who's our Twitter personality. Yes. We all came on in like 2014, 2015, and it's just been the same team ever since. We recently hired Jason Somonsato to fill Robin's role as she departed, and we had Landon Zinda for a time as well, who was a famously educated staffer on crypto issues in Congress, who then got a job with us and then got a job with the SEC. Yeah.
And then tell me, this is more even just a personal curiosity question, we're not knowing, but between the kind of mission at Coin Center, starting as a Bitcoin think tank, and then also as the industry has evolved with, blockchain and cryptocurrencies, what is the focus of the mission? Is it treat all cryptocurrencies equal, or is it how do you order the principle?
It's a good question. The reason I described it as a Bitcoin think tank is because I was talking about the history. And in 2013, if you were telling someone about this, or 2014, you wouldn't say cryptocurrency think tank, because there really only was one. Like, I think there was Litecoin and Dogecoin. Mastercoin might have just done their first ICO, which was arguably the first ICO ever. Ethereum, the Vitalik was like writing about it, and Vlad Zamfir was talking about proof of stake. One of those things happened a lot faster than me.
Yes.
But so we would describe it as a Bitcoin think tank at the time, because that's what someone in Congress who wanted to know what the hell all this shit was, they knew Bitcoin. But the mission was never to rep Bitcoin as the only acceptable version of this technology. We're not maxis. I do think that Bitcoin has many merits that no other chain can sort of match, in its some simplicity and in its just age and cumulative weight, now literally block weight. But our mission at Coin Center is to defend the freedom to innovate using permissionless blockchain technologies. And we define permissionless blockchain technology as in any, distributed ledger type system wherein anyone can participate in reading and writing to the ledger using commonly available hardware or software. So, we don't discriminate between proof of stake, proof of work. We just say, like, look, if your thing is R3 Corda, it's like only banks can join this blockchain network. That's cool. We've got no problem with that. You go do that, but we're not going to represent that tech. The banks can represent that tech. We're here to represent blockchains that are built on open source software and open consensus mechanisms, and make sure that they can be built in America, by Americans, exercising their rights to publish software, exercising their rights to protect their privacy, and then used by Americans for reasonable purposes, for lawful purposes, like holding your own money, like sending a transaction to a friend without an intermediary in between, the sort of self-custody stuff, censorship-resistant stuff, and ultimately privacy. Like if I have one critique for Bitcoin, and I'm very public about this, it's no secret, it's that, Bitcoin should have, I think, and who am I? I'm a lawyer. I know these are really hard technical problems, but I think Bitcoin should have taken more seriously the privacy problem inherent in a fully public, unencrypted ledger. And that's not to say that this was all a mistake, because God knows building privacy coins like Zcash and Monero and the more recent entrants like Aleo or Aztec is hard, and we probably weren't ready with that technology back in 2014. And maybe there's actually fundamental flaws in that approach. Maybe you really do need a transparent ledger for certain, assurances of verifiability or things like that. But my mission personally, and CoinCenter's mission, is also to support privacy. And that can include, using Bitcoin wallets in a certain way to maintain your privacy. Like we're very upset about the Samurai wallet prosecution. But we're also very upset about the Tornado Cash prosecution. And we're also, lobbying. We're not lobbying for any of the companies out there that are building new privacy chains, but we're lobbying as a public good for the freedom to build like fully encrypted blockchains. Like that should be something you're allowed to write software about in this country. And right now, kind of allowed to write software about it, but the DOJ might prosecute you for unlicensed money transmission, which is a pretty serious criminal felony. So.
And what did the program look like at CoinCenter, kind of from like, let's say maybe 2014 up to I might describe kind of in the last, in like 21 to 22, which is kind of maybe when industry woke up, Keep Your Coins Act came out. So like by part of chunk those years into 6 or 7 as an era, as it were. What did the early program look like? What were you doing? What was kind of the relationships in that in DC like?
So in the early days, a lot of it was education. It was just being able to go into an office, a congressional office, where maybe they'd recently gotten, letters from constituents about ransomware or something. And that was their first exposure to Bitcoin. And to explain that, like, Bitcoin is not a sketchy hacker company that's demanding money in their unique coin or something like that. It's actually, this great new peer-to-peer way of doing financial transactions online. And yes, it will be used by criminals, but it will also be used as a bulwark for liberty, for personal privacy, for personal autonomy. And so, we should allow it. We're happy to tell you about, how it works, why it's different than PayPal or Venmo or a bank, and why it shouldn't be regulated. Indeed, can't probably be regulated as you would regulate a typical bank, but also where there are reasonable places for regulation, like when a company holds Bitcoin on behalf of their users, and has control over that. That's not that different than PayPal or Venmo. And so, money transmission licensing probably should apply in that situation. So there's a lot of background education on just how these technologies work. I would always say like the question we did a lot of time preparing for, but was still nonetheless kind of a nightmare question, was when a staffer or a member in the office said, like, what is this mining thing? And then we'd have to find a way in a 5-minute conversation or a 5-minute chunk of a longer conversation, explain mining to somebody who doesn't have a background in cryptography or in open source software or in hash functions. And so education was extremely important back then, because there just weren't that many people explaining the stuff in a neutral way or in a way that was accessible to non-technical people. And lots of people in Congress are very smart. I think they get a bum rap. People are like, "Oh, they're all old and they don't know things." I'm like, no, they know a lot of things. They just have finite bandwidth, as we all do. So you can forgive them for not learning about strange new internet money in 2015, 2016. And so that was our mission. That was the prime part of our mission then, was that education mission. As things changed from a policy perspective, i.e., more existing laws, because it wasn't new laws, but more existing laws were brought to bear on different aspects of activities in our space, like ICOs, for example. A lot of them, especially the early ones, probably do fit under the flexible standard for what is a security and what is a distribution of a security that should be regulated by the SEC. We went into the SEC, actually, we were probably the first in like 2015, 2016. I had a deck about altcoins. I had a deck about Bitcoin and altcoins, which was the terminology of the day. And about why some altcoins, and I think I even had like Litecoin and other stuff in there, and some early like airdrops where you just like everyone who has, you know, Bitcoin public addresses with positive balances gets 1 unit of this. Why some of these don't look like they're securities offerings, but others where there's like somebody who hasn't built any tech yet and is just saying, hey, send me some Bitcoin, and once I build the tech, I'll give you some of this altcoin. Why that, you know, plausibly is within the SEC's jurisdiction. We also sort of tried to help them understand the difference between a permission blockchain and a permissionless blockchain, because a permission blockchain, especially if it had some sort of asset on it that the permission stakeholders all own, probably does look like a public corporation of some sort, whereas a permissionless system where the units emerge through mining or some other open competition rather than by fiat, probably not in the SEC's jurisdiction. So we were like sort of the first in their offices and in the lab that they had set up, educating about that, but also educating with an eye towards ultimately we need to have a clearer definition of the Howey test so that we're sure that Bitcoin is not a security, because that would be nonsense. Who's going to do the S1 filing? Is it going to be like, you know, Greg Maxwell? I don't know, right? But that some things probably are within the SEC's jurisdiction, and they should take a careful approach to explaining that and not surprising people with enforcement actions, but rather getting them comfortable with the idea of how they could fulfill their obligations. That was back, you know, with Clayton's SEC, and then obviously with Gary Gensler's SEC. Once Biden got elected, things got much more aggressive from the SEC. And so our posture changed a little bit from education and laying policy groundwork to basically threatening to bring lawsuits on constitutional grounds. So like a lot of people remember the enforcement actions against Coinbase and Kraken and others. It's also worth noting that the SEC had this pending rulemaking to define exchange for purposes of SEC exchange regulation as anyone who makes available a communications protocol, which is like, ostensibly it was aimed at Bloomberg terminals and Bloomberg, because they're not regulated as an exchange, but people do trading on Bloomberg. That's a whole complicated subject in itself.
Messaging or something like that?
Yeah, because it's a chat, right? And so they were like, well, the chat should actually be regulated like an exchange. And, you know, so the original rulemaking didn't mention anything about crypto, but obviously making available communications protocol is that people use to trade securities, or arguably securities, could cover everything in our space. And so we fought back on that. We wrote a comment that basically said, these are all the reasons why this is effectively a prior restraint on speech if you apply it to open source software publishing. You should be transparent that the rule you've drafted could cover a bunch of that. And so that's sort of a flavor of what things were like under Gensler. You know, setting the securities regulation bucket aside for a second, the anti-money laundering bucket has always been hugely important as well. In the early days, there was issues with state money transmission licensing, like the BIT license. The Uniform Law Commission was drafting a model law for states. We worked a lot with them, actually, to create one of the first tests for when you have control of other people's crypto and therefore should be regulated versus when you don't. It was when you can unilaterally execute or prevent a transaction on behalf of a user. So even like a 2 of 2 multisig with no time lock, you would actually be obligated, but a 2 of 2 multisig with a time lock, like the Lightning Network works this way, you would not. Like, we were trying to get that right in groundwork really early. And we also did a lot of outreach with FinCEN.
And I think you did, or like that was definitely one of the great moments. And we had some work with some of that ULC group, working group.
Yeah.
Early, we're taking loan. Bitcoin is collateral, and so like security over your collateral is important. And we do a multi-sig approach to how the loan collateral is held. And so finding that definition, or just it was a pleasure just as like an industry person when you get to find that a correct conceptual definition of something put so well and so simply that then it's just applicable like everywhere else. So great.
Yeah. And I think that work at the ULC fed into FinCEN's guidance in 2019, which said that, we're only going to treat as BSA obligated money transmitters those who have total independent control of customer funds. And I think FinCEN actually set great policy there. More recently, as things kind of got heated, we saw the DOJ prosecute the Samurai Wallet developers and the Tornado Cash smart contract developers for unlicensed money transmission, even though they don't have total independent control of customer funds, qua the FinCEN guidance. And, this is, once again, like Coin Center was there early to try and lay the groundwork for good policy. And I think we were quite successful. See the ULC, see the FinCEN guidance. Even with that groundwork, though, when there were hostile sort of approaches to this technology in the administration and in the agencies, we had to say, look, you had all this great groundwork, you had this great guidance, like, why are you suing people now? And by the way, that's unconstitutional. And so, we wrote amicus briefs. We've brought 2 lawsuits ourselves against the US government, against the Treasury. So the posture of Coin Center shifted from education to sort of groundbreaking early policy work to impact litigation. And, at various points, we've been more or less successful with one or the other, but those are our big strategies.
Great. Well, I love the arc. I mean, it's clear sort of in the place you all occupy is it's not, it's not lobbying for commercial interests. It's not about this, this area of it's these like freedom, this frontier of technology. I like and enjoy that part about your inception story into this. And that's part of what I think is new and trying to open up a little bit on now, like the what the frontier enables that may have precedent and may not.
Yeah.
I'd be curious just kind of how your thinking has evolved there. Self-custody being one I want to make sure we underscore, but then if there's other neighboring, concepts or things like that, just about maybe take the kind of technology lens on this, like what are the new capabilities it opens up and what precedent do and don't we have? And then I'd love to have a follow-on that's a little bit even like a constitutional history idea of like how any of this stuff intersects with like what our framers drafted in our Constitution and Bills of Rights kind of thing.
Yeah. So it's funny talking with Congressman Tom Emmer, who's been a great champion, and Congressman Warren Davidson, who's been a great champion for this tech. They're really interesting. I was about to say guys, but you're not supposed to call congressmen guys. They're really interesting gentlemen. Yeah. Because when we've interacted with folks in Congress, you find there's either people who hate crypto, and then there's broadly speaking 2 types of people who like crypto. And some are the like very interested in like blockchain for business use cases, like supply chain technology, like Hyperledger, IBM stuff. They're into the crypto, they're into whatever. And then the other are actually more like old school civil libertarians, private people who deeply value our First and Fourth Amendment rights and the unique experience of America and the revolution and like the nation we became, which is like the frontier spirit, got the individual autonomy and all that. And Davidson and Emmer are, I think, prime examples of like, they'll be the first to tell you they're not the most technologically sophisticated. Like they don't have a deep understanding of cryptography, but they immediately understand what Bitcoin is trying to do. And it's important to them because they see this arc of history. Bitcoin's not creating new capabilities, really. It is, but in a very specific way. Bitcoin's more reviving the capabilities that used to be the default.
Yeah.
Like our economy used to run effectively on bearer instruments, cash, bearer bonds, stocks. And that term bearer instrument has become villainized because of like movies like Die Hard, where Hans Gruber's like trying to steal all the bearer bonds, like millions of dollars from the Nakamoto Tower. It is the Nakamoto Tower, right?
Yeah, it is.
That's a weird tie-in. I didn't actually remember that.
Yeah.
Right? But like, that's all sort of like this like wave of villainization of those old techniques as we were like intermediating everything in the 70s and 80s and like all paper is dirty. But like America's economic history, especially when we were this dynamo of economic power globally, was all about like a peer-to-peer economy primarily. You know, this was before intermediation. This was before all of your transactions were done through a credit card or a stockbroker or a bank. And we should be that country again, fundamentally. Like, and we can be. Now, that was an in-person economy. And obviously, having peer-to-peer transactions online, you run into the double spending problem if you're not in person. Like someone is going to send you the same Bitcoin twice, and you're like, oh, crap. They probably sent thousands of that same Bitcoin. And so Bitcoin solves the double spending problem. It makes a peer-to-peer economy with direct transfer, direct ownership, and no intermediation possible, even over the wire, right? And so in many ways, yes, it's a fantastic new technology. It's amazing. It's very high-tech. It's very futuristic. But it's actually much more old world. It sort of revives the disintermediated economy that was the foundation of the American economic system and the American political system back in the 18th and 19th century. And so if you're into that, you're going to like Bitcoin, irrespective of your feelings about technology. In fact, it might even like change your feelings about technology. You might think like, oh, big tech sucks. There's always a bunch of namby-pamby like people who want to control our lives and tell us what's good for us using their, you know, monopoly power. While Bitcoin's like an answer to that. It's like you can have great online services that afford you amazing abilities to do things like pay and be paid or identify yourself and be identified, et cetera, but you don't have to trust a Google or an Apple in the middle. So to me, this is fundamental. What's interesting, and you said you wanted to go into constitutional law, is that we don't have a constitutional right to cash.
Mm-hmm.
Like it's not in the Bill of Rights. And that's fine because the Bill of Rights says these rights are not exclusive. Rights herein not described or reserved for the states or the people. But that part of the Bill of Rights is woefully underinterpreted. It's much more helpful to have like an enumerated right that you can point to and reason about and have a series of Supreme Court cases on, like the First Amendment, like freedom of speech and assembly and religion. But there's no like, I don't know what it would have been. I guess the Bill of Rights is the first 10, so it would have been like the 11th Amendment or something like that, like a right to cash. Why? Not because the founders didn't care about cash, but because there was this assumption that was just a background reality of the universe. Like people can pay with cash. We don't need to enumerate a right because we haven't seen this alternative technological wave of financial intermediation through the wires, which didn't exist back then, that we need to guard against or enshrine at least the in-person option against the intermediated option. And so I sometimes refer to this as like your secret right to cash, because the framers, the founders, like the American ethos assumed you would always be able to pay somebody and be paid by somebody without having a gatekeeper in between. But they didn't write it down. So it's a secret right. It's a right we can only reason about in the abstract by looking at analogy and things like this. There is one thing, and Hester Peirce, commissioner at the SEC, said this in an incredible speech a couple weeks ago. This is the summer of 2025.
Watermelon speech?
Yeah, peanut butter and watermelon and thoughts about financial privacy. I think something like that is the title. And she said, we should understand our Fourth Amendment and understand that at the time that the Fourth Amendment was written, the Fourth Amendment is our right against search and seizure. It's a right to privacy against the government, that the government should only be able to look at our stuff or ourselves or arrest us for that matter with probable cause and a search warrant that's been, validated by a judge so that there's some, checks and balances in the loop. And she said at the time that the Fourth Amendment was written, almost all payments were done with coins with no record of the transaction. And so inherent to like how would you have even gotten a warrant to collect everyone's past coin transactions in 1795 or whatever, right? The judge would be like, I'm sorry, how are you going to get this record of all the coins that this person has taken out of their pocket and given to someone else? You're going to just like constantly follow them around and surveil them. That's not appropriate. That's a general warrant rather than a specific warrant, which is specifically in the Fourth Amendment. So Hester Peirce is right. Like, if you actually think about the Fourth Amendment from a privacy standpoint, and think about what it indicates as far as what's permissible for a government search or a government seizure, the Fourth Amendment's written at a time where it's assumed that you could never use that Fourth Amendment power to get at the entire dossier of a person's financial history, because most of that person's financial history would have been done using coins, which don't leave a record. And now today, most of a person's financial history is like on freaking Robinhood and Chase and Google Wallet. And yeah, they can easily get a dossier of everything you've ever bought and sold and when and why, and start profiling you and start figuring out how to get at you if they've got the wrong idea in mind.
And that it brings up, I mean, because the other, I like that you use the cash analogy, most direct an analogy to Bitcoin, but a lot of also have framed and just have explored this as private property.
Yeah.
That was also in the air of like that era, like, and even I know there's like nuances to Jefferson's life, liberty, and the pursuit of happiness, or versus life, liberty, and the pursuit of property having been another form of it.
John Locke, yeah. Jefferson took a little bit of liberties there. We'll forgive him. Yeah, the Fifth Amendment and the Taking Clause, it does articulate a kind of right to property, but it's got a lot of carve outs that are a little dangerous, because it can be your property can be taken by the government for public use.
Well, they pay for you
with just compensation, and so this is interesting. I hope we're never going to have to like do a lot of argumentation here, but if we came to a point one day where the government said you can't own Bitcoin, we will take it, but we will pay you just compensation. It would be hard. It'd be a little difficult to argue then that's manifestly and clearly unconstitutional. I think intuitively it makes sense that it's just sort of against the American spirit, but FDR and personal gold holdings. I don't know enough about this topic to actually like speak intelligently about it on this podcast right now, but there is a history there of like seizure of gold in the context of like macroeconomic pressures in the Great Depression and World War II. And so I don't know. I don't want to have that battle. The battle I'm interested in fighting right now is the battle for the First Amendment and the Fourth Amendment, which is like, if you're publishing software that allows people to hold their own money, you should be free and clear to do that without prior restraint, because you're publishing speech. And the Fourth Amendment, which says that you have a reasonable expectation of privacy for your personal effects, and your, Trezor wallet or whatever is a personal effect. So a search and a seizure of that requires a warrant and due process. The Takings Clause could become interesting if there was like an across the board seizure for public purposes, some like public policy. It's just bad for people who own Bitcoin, and then they try to give them just compensation. But yeah, there's a lot of moving parts there from a constitutional analysis. It's premature for me to opine.
Yeah, at least I've considered. I mean, as long as for that just price, although announcements of such thing can affect, but at least there is a market price all the time for Bitcoin, and to buy up to 40% or whatever that's held by Americans would at least be a considerable Terry.
That's true.
But yeah, it's fun because reading this stuff has gotten me thinking about that as well. And it's often not mentioned in the 6102 thing that it was that the government did still pay for what they confiscated.
Yes,
it's like it ruffled people that they then changed the price later, or like it.
It's funny, like. Yeah, so the seizure of gold was in like the 30s, right?
Yeah.
It was FDR, and they were all compensated. But are you compensated? That's the funny thing. Like, if you're forced to hold your wealth in a different asset, is that still just compensation if there's a fundamental difference between the asset, right? And of course, Bitcoiners would argue that there's a very fundamental difference between the assets because one's inflationary and the other one's deflationary. But I would also argue that one's a censorship-resistant online payment mechanism. So that's the funny thing about Bitcoin is it's not just an asset. It's a technological stack that enables a certain type of behavior across the internet. Yeah. And you could be like, everyone can hold Bitcoin. You just have to hold it at Coinbase. What would that? How does that fit into the Takings Clause? Unfortunately, I don't think it does. And this is not a screed against Coinbase by any. But you could see them saying, you're free to own your Bitcoin in your ETF funds.
Yeah.
You just can't own it directly because that's a national security risk or something like that.
And that's one of my hinges though, is then what did just happen there if in that thought experiment the self-custody part of Bitcoin's disallowed? And that's where I'm wondering how much is that a taking of private property? It's you've removed a capability now the person has. So that's somewhere where my own non-lawyer and thought experiment stuff has brought me.
Yeah. You mean what does the threat look like?
Yeah.
It's hard to say. I mean, in some ways it is, in some ways it isn't. I don't think there's a part of the US code that could easily be leveraged currently to say that by regulatory fiat, like the Treasury Department's going to say this, you are only allowed to own Bitcoin on an exchange and not allowed to own it in a wallet that you have the keys to. There's the Treasury has a lot of authority, statutory authority under the Bank Secrecy Act, under the banking laws, but I don't see clear authority for like a dictate like that. Now, more likely they have the authority to effectively say that like Bitcoin that's already on a custodial exchange can never go to a self-hosted wallet, or can only go to a self-hosted wallet under extraordinary AML KYC practices to the extent that no ordinary person would comply anymore, and all the Bitcoin would basically end up stuck on centralized exchanges. And we saw this a little bit with actually the first Trump administration, when at the very end of that administration, Treasury Secretary Mnuchin promulgated what's become referred to as the self-hosted wallet rule, which would have been binding not on people with self-hosted wallets, or unhosted wallets. They use the term unhosted, which is just kind of a silly term, but binding on like Coinbases and regulated financial institutions. And it said that if you are working with a customer and the customer is directing you to pay a Bitcoin address and it's not another financial institution, another Coinbase or Kraken, then you need to collect this excessive dossier of information about that address. Like, who is it? What's their home address? What's their other stuff? And at that point, you have obvious privacy concerns because the government shouldn't be hoovering up that information. Coinbase or whoever the financial institution, they have no right to that information. Like that person might be their customer and it's their wallet. It might be some stranger to Coinbase, and they have no business knowing this other person's background information. They have no contract with Coinbase. They have no promise to, fiduciary duty to keep private that information. And so it's manifestly inappropriate to tell them to collect that information about third parties. And so we commented at the time, we fought it, and it died on the vine. It was sort of at the end of the Trump administration, the beginning of the Biden administration. So I'd like to take some credit. Like, there was a big response, our comment and a lot of other comments about how bad this is. But it could also just be that when a new administration comes in, they tend to drop a lot of the rules from the previous administration. It's sort of just the general policy, especially when it's, party switching, Republican to Democrat in that case. And, during the Biden administration, we saw a lot of proposed laws in Congress, like DAMLA, which is the Digital Asset Money Laundering Act from Elizabeth Warren, that would have created congressional authority to treat self-hosted wallets as financial institutions under the Bank Secrecy Act. So not only would you not be able to move your money from Coinbase to your personal wallet, by virtue of operating a personal wallet, you'd effectively be a financial institution under the BSA, and you need to collect information about all the people you pay and do all the compliance that a bank does for your own money. It makes no sense. It effectively is a tacit ban. It would outlaw performing that activity because the compliance obligations would not be fit for purpose and would be impossible to comply with. And so you'd just by default, if you were doing that activity, be violating the law. And so, we've seen this arc a couple different times, and we constantly come back and we fight against it. But an outright ban on self-custody would be in the extreme, and I don't think could be easily done through regulatory power. That said, Congress can always write new laws, and unless it's unconstitutional, unless you can argue that it violates the Takings Clause or violates the Fourth Amendment or violates the First Amendment somehow, you're going to have trouble fighting against that outside of the political process, which is just getting better representatives in Congress who will not pass those laws, right? And so, it's a real problem, and it's something that we have to be vigilant about. We're not going to amend the Constitution, I don't think, to get a right to self-custody, though we should. And we can do sort of prophylactic steps like the Keep Your Coins Act, which say that nothing in the existing U.S. code can be used or misused by regulators, by the administration, to seize or prevent self-custody. And Warren Davidson, as a champion for that legislation, deserves tons of credit. Like, it's a very important piece of legislation. That said, a future Congress that's hostile could overrule that law. Like, new Congresses overrule old Congress laws all the time with new law. So it's an important area, and it's one where we just have to constantly, we're not just trying to get more money for Coin Center and more money for lawyers, but this is one area where, like, we have to constantly have good lawyers watching this process and lobbying to make sure that we don't go down the wrong path.
I appreciate you brought it kind of together between some of these acute battles and what was there in the 21, 22 environment that led Davidson to introduce the original Keep Your Coins Act. And I like it's sort of I think maybe Seth who put it this way. It was like the penumbra, there's an idea of, it might be a legal theory idea, or maybe it just is, but it's just like when you have these like this right to self custody, it's evident to you and me. Maybe we go back and read the framers, or we read the context in which the Constitution and early bills of rights were written, and then we can place with our view the idea that self custody would have been the kind of thing included in that sort of list. And then the fact that maybe there's enough, and just by the number of like what is established, like, yeah, you'd believe like self custody is like within this. And then the arc you described is that kind of people like Davidson and Emmer, who in their roles as lawmakers are like, they have a version of a personal philosophy or view on the role of the state and personal and things like that. That this is like, yes, this is part of like the long arc of history, of the arc towards better, more perfect government, to have certain rights and capabilities exist. And it's been fun because talking in this, there's a way naively thinking about Clarity Act language. If I wasn't careful or more nuanced, it would look like, oh, this is a fight to protect self-custody, or fight to save, or keep self, the people I seem to talk to, especially Zach, when it goes like, oh no, we have the right. It's so clear. Like, don't be chill, industry. Like, we have a lot going for us in terms of like what it would take from the legislative body to like actually write laws that ban this. I think
that's right. Yeah.
It'd be a steep hill for them.
I think where we have more danger, and this is not to say that the Keep Your Coins Act is not important, it's important, but where we have more immediate danger, just evidenced by prosecutions, is on people's right to write software for self-custody.
Yeah.
And so that's like the Samurai Wallet case. And it's remarkable. So yeah, if you look at these two threats, the Mnuchin rule at the end of the Trump administration is the best example of the direct threat to like being able to physically move your Bitcoin from a custodian to something you control. And the most direct threat to not being able to even obtain self-hosted wallet software or publish self-hosted wallet software is what happened at the end of the Biden administration, when we saw the DOJ prosecute the Tornado Cash developers and the Samurai Wallet developers for a violation of the criminal code 18 USC 1960, which is the unlicensed money transmission statute. And, these prosecutions were way off base for a number of reasons. I think broadly they're off base because we should be encouraging people to write open source software that allows people to hold their own money. And holding them criminally liable by the misapplication of a criminal statute related to like Western Union money transmitters is going to chill that behavior to the extreme. And that's inherently un-American. Also inappropriate because it's against the First Amendment. Like, you should have a right to publish wallet software. Now, these guys, in both cases, were doing a little bit more than just publishing software. And so sometimes our First Amendment start to break down a little there. I actually think they're still quite strong. We can get into that. But then the other reason why these prosecutions were just way off base is that just a couple years earlier, FinCEN, the regulator who sets money transmission Bank Secrecy Act policy, said that you're not a money transmitter if you don't have control of customer funds. If you are just, for example, a software provider, an anonymizing software provider is a term that they use, where you provide software that allows people to hold their own money and transmit their own money. You are not, in that case, a money transmitter for them and don't need to register. And so the fact that people are being charged with failure to register when the regulator said you don't need to register is a due process violation.
And what changed there? What was the best hypothesis as to why the reversal from that previous policy setting?
So I can only speculate so far because the Department of Justice is big and it's decentralized. And both these prosecutions came out of the Southern District of New York, which historically has been, this effectively global policeman for financial crimes. Going back to when, Wall Street was where all finance, like all roads led to Wall Street instead of Rome. And so because of that, they would claim jurisdiction over like a fraudulent transaction involving mostly like Ecuador and, Taipei. But yeah, at one point it touched Wall Street. So we can police that. And it became a very aggressive prosecutorial office. And, prosecutors, I don't mean to impugn prosecutors, but prosecutors are not policymakers. They're not weighing the equities of like, what's good policy for America?
Yeah.
They're there to win cases, get judgments, and get,
advance their career.
And not just advance their career, that, with civil asset forfeiture, with criminal asset forfeiture, like this also funds the department. So the incentives there are aligned in a very specific way. And that's probably okay as long as we have really good defense attorneys and they don't cross these lines into just manifestly rewriting the US code in order to charge people with crimes that are not actually crimes. And so you see how the incentives line up. The Biden administration, in some ways, neutral on crypto, in some ways, no friend to crypto. Again, highly distributed, many different people in that administration, some friendly, some unfriendly. Obviously, the SEC was a flashpoint of very anti-crypto policy. Perhaps, and I'm completely speculating at this point, maybe there was some back and forth between, say, Gary Gensler's SEC and the Department of Justice on, how this stuff probably should be squashed using this kind of criminal code. But this is just complete speculation on my part. Might have just been people who'd been in the SDNY for a long time and saw that the administration was taking this more aggressive approach and saw it as opportune to themselves and their careers to go after these people for publishing wallet software. Suffice to say that happened. That change happened. We went from FinCEN, which is a discrete regulator, it is not connected with the DOJ at all. It's a subdivision of Treasury having this really good policy, to this completely separate wing of the federal administrative state, the DOJ, saying that policy is irrelevant. If we want to charge people with crimes for failure to register, we're going to charge people with crimes for failure to register. And the shift at the end of the Biden administration was pretty profound. I'm still very bothered by the fact that the DOJ continued with those prosecutions up through the Trump administration until we ultimately got a guilty plea from the Samurai developers and a guilty verdict on the unlicensed money transmission charge in the Tornado Cash case. Personally, I think the Trump administration should have done more to push the DOJ to drop those cases. Now, that's actually contentious because the DOJ claims political autonomy from the president because they also have to investigate the president. And so it's usually unusual for the president to pressure the DOJ to drop already existing cases. We do know, I can't share details, but we do know that a number of ongoing investigations of, some software developer type targets for unlicensed money transmission were dropped. Some very high profile cases, including cases where people had like their homes searched and things like this. And so that might have been a positive sign that there was a turnaround or there was a change there. And then more recently, we've seen the Deputy Attorney General, Todd Blanche, issue a memorandum saying we're going to end regulation by prosecution. We're going to stop bringing charges against, developers for innocent failure to register. We're only going to go after folks who knowingly facilitate crimes. That's good. Like, that's the right intuition, but it's also a little weak as a protection because you can kind of impute criminal intent or knowledge of criminal usage of your tools to anybody in the space. Like if you're writing open source software for a privacy preserving Bitcoin wallet, I'd be lying if I said I was publishing that software without knowledge that someone's probably going to use that to launder money. I don't know who they are. I'm not involved with them. I don't want them to do this either.
To help it. Yeah.
But like at that point, is that the knowledge requirement that you're talking about? Because that's not okay. That means everyone publishing open source software is potentially, on the chopping block. So we're still here. There's been a change of tune, kind of like there was a change of tune from Trump 1 to Biden on the Mnuchin rulemaking. But these things just keep coming around and around and around. And right now, I am more concerned about liability for unlicensed money transmission than I am about like bans on self-custody or impediments to self-custody.
So if I separating some of these out, there's self-custody where like we know it would be a dark day for the US if it was outlawed on self-custody in it. But the odds are so low, or like it is such a low odds, so high stake, but low odds. So average.
More likely they try to put like extremely difficult hurdles between moving from custody to self-custody.
And that's where the Keep Your Coins Act comes in terms of providing a check to that.
And that's why killing the Mnuchin rule was important at the end of the last Trump administration.
And just before, because I do want to set up and spend some time on the publishing code and to like self-custody wallets thread, but on the Keep Your Coins Act and the stakes related to that, what do you view as the odds to that passing this between end of year, between now and then, like in the form of either part of the Clarity Act or in some other motion at the Senate?
Yeah. Passing standalone legislation is very difficult. So you really got to get your text onto something that's likely to move. And right now, the best vehicle for that, for Keep Your Coins and for the Blockchain Regulatory Certainty Act, which addresses the wallet publishing issue, the best vehicle for that is Clarity, because it's like one of the two big bills that the Trump administration has made its showcase of like creating good crypto policy that actually puts guardrails in place, but also clarifies legal ambiguities. And so the fact that Keep Your Coins in some form, and there were adjustments to the language, has ended up in the House passed Clarity and is in the discussion draft in the Senate as they start to take up market structure is a positive signal. And we just need to fight to make sure that it stays in the Senate version. And then if it changes at all, can be easily reconciled with the House version so that we can end up passing it into law. And that's true of both the Keep Your Coins Act and the Blockchain Regulatory Certainty Act. There are other paths for these things. We could attach them to some other must-pass legislation, like a common tactic when you have a fair amount of political capital, which we're starting to have as an ecosystem. A common tactic is to attach something to the National Defense Reauthorization Act, the NDAA, which is like the bill that funds the U.S. military. So people usually don't mess around with it, but they don't filibuster it and things like that. And so that's possible. There's also a different potential path, which is to do it through budget reconciliation. And that also has a lower procedural bar as to like filibusters and other things. But for that, it has to be revenue relevant, which means it has something to do with taxing and spending. And it might be, unless you rewrote it in a way that was more obviously related to government taxing and spending authority, it would be difficult to argue that that is something that could be in reconciliation. But there's a couple different paths. Rewrite it to make it more obviously related to taxing and spending, put it on the NDAA, put it on Clarity is, I think, the most likely path right now. Clarity, which is the House version of market structure, and Senate's working on its own new draft of market structure legislation, I think it has a shot. It's very hard because passing legislation is very hard. You have national security concerns on the AML side that will come to bear, especially in the Senate, especially probably with more skeptical Democrats. Like Elizabeth Warren's never going to vote for it. But a very interesting question to me is whether a Mark Warner, who takes national security concerns very seriously, can get comfortable with a certain AML package for regulated entities. And whether he would then vote for it. You have these sort of moderate Democrats who are key to passage, because without some Democrat support, you can't get by the cloture vote to actually get the legislation passed. So these will be interesting questions. I do think we've got a good shot. We got the best shot at passing legislation we've had ever. Like the Genius Act is now law. So the one of those two bills I mentioned did actually move quickly through both Senate and House. So I'm hoping Clarity can do the same.
And it sounds like the more active front is on the software developers. Like that's where the heat of the battle is, and so it's not people aren't things are going to get really shot down or like stuck in mud here in the next couple months. It's around that, and
maybe
so, like People Coins piece is like a collateral damage, or just not. It's not that people aren't like lining up to take sniper shots at that.
It's funny that people also aren't lining up to take sniper shots at the Blockchain Regulatory Certainty Act, which is the part that clarifies that money transmission licensing laws don't apply to non-custodial devs. Very important piece of legislation, originally introduced by Tom Emmer in the House back in 2018, actually. So been there for a long time, and has been bipartisan actually in every introduction, and most recently has Richie Torres, a Democrat from New York, as co-sponsor, but also Gottheimer, another Democrat, and Huizenga, another Republican. Like good bipartisan support in the relevant House Financial Services Committee. Got attached to Clarity. We were concerned that there might be politics about this. Like people would be like, that's the part that is going to make me vote no, especially if they were maybe a Democrat who we needed to convince, because they're naturally skeptical of crypto because of, perceiving it as like, it's all Trump's thing. Trump is pro-crypto, so maybe I'm not pro-crypto. But in the end, the negotiations in the House mostly focused around the ethics rules related to Trump's family. Like, should Clarity ban, public officials and their children from issuing coins and things like that? Or are the existing ethics rules for securities trading and other things and conflicts of interest sufficient? And a lot of the Democrats wanted really tough language to say that, the Trump family is not allowed to do this shit. And that became a sticking point instead of the BRCA being a sticking point, which I was happy about, because I don't think the BRCA to me is nonpartisan. In fact, there's 20 good reasons for a Democrat to like the BRCA as there are for a Republican to like the BRCA. Like, if you value speech and the ability to just, write ideas out and not have them censored by the government, if you value funding NGOs or charities, or like, you need these tools to exist in the world. And if you value the rule of law, if you think like we should only be arresting people for crimes that are obviously crimes.
Yeah.
And the Democrats more often than not are very pro criminal justice reform and against over criminalization. Like the fact that we're charging people with failure to register when the regulator said that they didn't need to register is just an offense to the rule of law and the idea that like you're innocent until proven guilty. So I'm glad that it's so far been nonpartisan. As it moves to the Senate, the BRCA is in the Senate version. I'm optimistic that we can keep that going. We'll see if national security concerns, which could be either on the Republican or the Democrat side, become a counterbalance. That said, I don't think those national security grounds for passing on the BRCA are well grounded, because like, you're not going to effectively ban the publication of software. If anything, the people who publish the software will be more likely in China and in like Russia. Right. And then that software will still find its way to the US, and it'll probably be like backdoored and buggy and bad. That's a national security issue as much as anything else. So villainizing American software developers who are actually building like the cutting edge of tech for how you move money around the world is a bad approach in the long run to national security, because you want those people here. You want them cooperating with law enforcement investigations. And that means not antagonizing them. And it also means allowing them to do their research and their publication. Right. So, yeah.
And I'm struck by, and I want to do more my own homework on the 90s, the battles in the 90s over cryptography, just in terms of, because that has a similar breakdown in terms of either the use or like the publication and creation of cryptographic protocols and standards. How well studied? We mentioned that like you were both in high school or something in those eras, so weren't paying attention to it contemporaneously. But then later, have you studied that well enough, or how well does any of the parallels there inform what your work is here?
Oh, they're very real parallels. So if you think about US v. Bernstein, which was a case where the US government sued a academic cryptographer who was trying to publish, I think it was RSA, the RSA encryption system, online. So it's strong encryption, large key size, and the US government at the time classified strong encryption as a munition, a weapon of war, that therefore you are not allowed to export. You're not allowed to take across the border. You're not allowed to, and if it's an information product, publish widely in a way that would ultimately end up in the hands of our enemies, in the hands of the Russians or the Chinese or whoever we think our enemies are at a given time. And so Bernstein sued, saying, I'm a professor. I just want to publish a strong academic crypto system that's important for the advancement of science and also for people's personal safety and business safety. And people need to be able to study and reason about these things for them to exist. And, that case progressed up through the Ninth Circuit, never made it up to the Supreme Court because it kind of looked like he was about to win. And he did win some appeals judgments. But the government eventually just backed down, and they were like, all right, we won't classify RSA as a munition anymore. And so the case was ultimately dismissed for mootness. It set a bit of a precedential record in the Ninth Circuit, which is also persuasive for other circuits, that the government on First Amendment grounds is not allowed to put a prior restraint, a licensing requirement, or a export control requirement on the publication of code. And this is not just any code. This is encryption code. This is highly relevant to crypto as in cryptocurrency. And so that battle was fought, a win/stalemate, because we didn't go all the way up to the Supreme Court. I wish we had, as long as we won. And it's very similar now to some of the arguments that you see, we wrote an amicus in Roman Storm's Tornado Cash defense, saying he has a First Amendment right to publish these immutable smart contracts. He has a First Amendment right to maintain a website and a web server that provides a user interface, assuming he's not actually acting as a fiduciary for the users of that website. It's just a user interface. And so we're testing those exact same principles again. And so that was on the publication side. On the actual use cases side, the parallels are also somewhat similar. In the early days of criminal liability for being a server on the internet, where this is not running a Bitcoin node. It was running a newsgroup server or a message board server, in the old way that we used to do social media, if you want to call it that. People would have their homes raided because there'd be, defamatory content on the server or criminal content on the server. In the worst case, child pornography. And they'd be held liable even if they had no control or knowledge of the stuff on their server. They were just they were a message board. Other people should be held culpable for things, especially things like child pornography. But someone who's just playing an infrastructure role on the internet, we can't do that because the internet just won't work then. And so the Communications Decency Act was an important lobbying battle in the 90s and early 2000s, where we said, look, persons who are information services providers on the internet who repost or allow people to post user-generated content cannot be held liable for state criminal or defamation charges for that content. The user should be held liable, but not the person who's just infrastructure. And so, you almost had a situation back in the 90s and early 2000s where nobody except an extremely well-moneyed huge corporation would have the ability to be part of internet infrastructure, because they wouldn't be able to fight all the potential legal liability for hosting content, for hosting other people's content, and for being part of that infrastructure. And that's why we created the CDA 230, which was this insulation from liability for those publishers, or those publishers of user-generated content. Same thing with the Digital Millennium Copyright Act. If YouTube, back before it was owned by Google, when it was just a startup, was going to be liable for all the copyrighted content that was ever shared on YouTube, YouTube would not be a viable business model, even for a big company like Google to do it, although Google wasn't big at the time. And so the Digital Millennium Copyright Act had this safe harbor provision, which said, if you have a notice and comment or notice and takedown service, where if you get a letter that's got the right facts and allegations about copyrighted content, and then you either challenge the letter saying, no, this is a specious claim, they have a right to publish this, or take down the content, you are, as a republisher of videos, able to continue to do this without vicarious liability for copyright infringement. So like we had these battles over fundamental questions of like, are people going to be able, especially people who don't have a lot of money for legal defense, able to participate on equal terms as part of a user-generated internet, like a peer-to-peer internet. And we got some big carve-outs that were important to the viability of the internet at the time. There's an interesting retrospective to be had as to whether those were ultimately healthy policies. And this is a little spicy. Carve-outs for liability, are there to ostensibly protect the little guys, right? Everybody should be able to run their own home web server, and they shouldn't be like crushed into legal liability just for doing so. But that's not what happened. The companies that run the intermediated businesses republishing other people's content, the ones who ultimately benefit most from a liability shield, became huge monopolies that basically created walled gardens that became the future of the internet. Like nobody has like their own personal blog on their own personal server anymore. They all have an Instagram page or a Facebook page. And it's probably still important to protect Facebook and Instagram and Google and whoever from liability for all their user generated content. But the pro decentralization cypherpunk in me kind of wouldn't mind if they were sued into oblivion. But you can't have it both ways, because then like we're going to have a liability shield only for like individuals and not for corporations. That doesn't make sense either.
Right. And it's not that the, at least I might posit that some of the reasons why those businesses became what they are in terms of that increased fat, like they were supported by other factors of that advantage scale. Not necessarily anything like legally or like structurally about how the laws were set up. So I guess in that retrospective, are you saying, is there something that could have been done? I mean, short of, as you say, excluding corporations from that benefit and making it only that individuals have the liability shield, or is there something else that is otherwise a way it could have been set up differently? Or, again, to the idea.
Yeah, no, I think at the end of the day, this is probably the best of all worlds of what's possible. It's hard to think about alternative histories. Because
now we did get at least like the Bitcoin, the blockchain, like these other then allow the cypherpunk promise to kind of come back.
To hopefully come back, right? And we need. I think that's where we should focus our efforts from a policy standpoint. Is not how can we use the levers of government policy to break up Google by taking away their liability shield or by using antitrust to break them up. It's more how can we ensure that there are new small companies or small individual open source software projects that can build tools that are way better than what Google has, and Google will ultimately fail under the weight of its own inefficiencies, as the market would generally dictate through Schumpeterian creative destruction. That's like my preference. But there's a potential naivety there. This is something that worries me about like self-custody and things in general is, most ordinary people aren't ideological. They just use the tool that's easiest, right?
Yeah.
And there's an interesting question whether something about a self-custodial Bitcoin wallet or maybe it's something more like, all the rich internet activities that you might do on the future on a blockchain, or might want to do on a blockchain, because that way you don't have to have like Google in the middle. Like, is that ever going to be way nicer for an individual to use than the centralized alternative? Probably not. But I don't mean to be cynical. And if that's the case, then maybe the only people who ever use this stuff are sort of more like they're ideologically motivated, they're very technologically sophisticated, and maybe that's enough. But I think about BitTorrent a lot, because BitTorrent is in many ways a much better way to do file sharing and storage on the internet. And it's silly that I still download Windows from like a centralized like Microsoft server. If I download Linux, which you can do legally because Linux is open source, I would download it peer-to-peer because it's actually faster and it's kind of, it's a sensible way to distribute software. But that's weird. Like most people don't torrent things anymore. And the few things that they do torrent are, like copyrighted content. So BitTorrent as a technology kind of ended up in a backwater. It's still around. It'd be very difficult to outlaw it from first principles, but I don't think even there's much political will to outlaw it because it's not even doing that much in the world. Like occasionally people use it to violate copyright laws, and so I worry about, I think there's something fundamentally different about Bitcoin and Ethereum and, digital scarcity though, in that
the convenience is what comes to mind in terms of that influence or the influencing factor of like humans will just choose the more convenient, easier thing. And but then when it is Bitcoin or it's wealth, and that's what gives me hope, at least in the idea that Bitcoin has driven like the consumerization of cryptography into hardware wallets or into something. It is just yet a little more easier to use or grok than like what PGP email is still to people in terms of like a high barrier.
I also think the stakes are higher even for ordinary people than they were in the BitTorrent context. Like, I guess I have to pay Spotify. I can't just download MP3s. Is a little different than, I guess I have to use the regulated banking sector to do all my financial transactions, and they constantly shutter my account because they think I'm a radical, but actually I'm not violating the law, or not even they think I'm a radical because like the AML system is broken. It's like my name is similar to somebody on the OFAC list. Like there's so many inefficiencies in the way that centralized finance is done right now that make it actually a really bad consumer experience. That maybe that's enough to convince your ordinary person who's more interested in convenience than ideology that, a self-hosted wallet might be in some ways a little less convenient. Hopefully it's no less convenient. Hopefully we can just build really good tools. But even if it is a little less convenient, it's worth it. But there's a huge education gap there because most people don't really spend a lot of time thinking about how money works, let alone how like the pipes that money flows through work. So we'll see.
It's complicated. And so I'm definitely, just in terms of the frontier and where it's at, I feel like there's a way, like the frontier of the 90s and the EFF they were talking about had to deal with, it's kind of like this new thing comes out, and then we discovered, okay, something like the munitions rules or these things were some antiquated stuff that like really impinged or held back its promise. It feels like in the current environment, where this frontier of self-custody, self for unhosted wallets, we're dealing with like the drag BSA, that's kind of the main culprit or the main ball and chain kind of holding back some of the promise and open capabilities of this. And we may get some victories with the pending legislation or the stuff in process to help protect or help curb things that might impinge on the right to self-custody, and also protect the developers that publish and might host some of the software for this. Is your job done then? Like, what sort of like, if you, it was funny talking to Seth about, these past, by end of year, like, what are you doing? It's, I'm going to the beach, drinking Mai Tais, there's a lot of people maybe like you that have been on the front lines here, maybe just take a pause, but is that true? Or, there's a ever expanding frontier, of course, but these feel like potentially.
Yeah. Passing the BRCA and the Keep Your Coins Act as part of clarity would be a massive victory. It would be the clearest statement from Congress, both from a messaging standpoint and from a legal meat standpoint, that like we are going to protect American developers and American users of this tech, right? And that would be, yes, I would take a nice vacation, but it would just be a vacation. I got to be back in DC. A few things. The Bank Secrecy, the Bank Secrecy Act, you rightly flagged as sort of like probably the law that could be most easily manipulated to crush the the liberty and privacy interests that people have in using these technologies. And it would be a misapplication of that law, but it would only be barely a misapplication of that law. So, you know, the BRCA would say you're not a money transmitter, but there are other categories of financial institution. And the Department of Treasury is actually empowered by the Bank Secrecy Act to say that anyone whose records are useful in the ongoing course of a criminal or tax investigation can be made to report, per the BSA, information about their transactions. And there's another part of the definition of financial institution that says that the regulator can identify other entities not listed as financial institutions, not listed as money transmitter or whatever, that are substantially similar to those and obligate them. So there's still a lot of very broad and in some ways ambiguous statutory authority that gives Treasury the power to obligate all kinds of people in this space and effectively outlaw these technologies through crushing, you know, AML control rules that don't even make sense when they're applied in that way. We have a few lines of attack there. One, the BRCA says that, you know, after the enactment of the BRCA, at least the version in clarity, Treasury can't create new categories of financial institution that are substantially similar to money transmitting obligations.
It then limits the growth of that definition.
Yeah. Now, then we'll have to argue like what is substantially similar, right? And so that gives us something to argue. The other issue inherent in the Bank Secrecy Act, and we wrote a very long legal report about this for people who are listening who are constitutional nerds. The Bank Secrecy Act is often attacked for being potentially unconstitutional in certain applications on Fourth Amendment grounds, because this is mass data collection of private, intimate, personal information without a warrant. Now, the reason why that's not inherently unconstitutional across the board, the reason why a person in the Southern District of New York can call up Bank of America and say, like, give me Joe Kelly's full banking history, and they'll do it without a warrant, is because of a couple Supreme Court cases back in the 70s, California Bankers Association versus Schultz and Smith and US v. Miller, which said that, once you give your information over a third party, including a bank, you lose your expectation of privacy in that information, and it's fine for the government to go to that third party and get that information without a warrant. That decision has been narrowed a little by a recent case called Carpenter, where the government was going to cell phone companies and getting your full geographic history, like where you walked every day without a warrant. And the court was like, yeah, that's not okay. You need a warrant when you get that from a third party. We're going to have a limit to the third party doctrine there. But that has yet to be extended to financial services of any kind. Yeah. And it should be, because the records that financial service providers have of you today are far more comprehensive and damning and, well, not damning, far more like violative of your privacy than the records that they would have had in the 1970s. Because in the 1970s, you would have done like a handful of transactions with your bank per year, like your paycheck, an auto loan, your mortgage. Now you do everything. Like, they could have a rich portrait of your entire life. So it should be, the Fourth Amendment should step in to limit the application of the Bank Secrecy Act, and we would potentially fight that fight if they were coming for software developers. We would fight that fight in court. The other area, and actually I should say we are fighting that fight in court, not in the context of the Bank Secrecy Act, but in the context of the tax laws. So at the end of the Biden administration, or no, in the beginning of the Biden administration, they passed the Infrastructure Investment and Jobs Act. And one of the things that came in that big package was an amendment to the 6050I reporting requirements, which are part of the tax code. And the 6050I reporting requirements typically applied to cash transactions, coins. If you, as just an ordinary person engaged in some business dealings, like say I'm selling an antique desk or something, if you get paid more than $10,000 in cash, you have to collect the name, social security number, and home address of the person who just paid you, even if you're just selling them a desk, or let alone a used car or something like that. And the Biden administration and Congress, last Congress, passed a law that says that now applies to crypto. And so that means if you're getting paid $10,000 or more in crypto at a self-hosted wallet, you need to collect the name and social security number and home address of the person who just paid you. And in theory, that even applies to Bitcoin miners who get a mining reward, that's a $10,000 or more payment. Whose information are they supposed to put down? Makes no sense. And it applies to charities like Coin Center who receive donations, because the IRS's notion of transactions in a business extends also to things like charitable giving, which is kind of wild. And so we need to collect the name, social security number, and physical address of all of our donors according to these new 6050I rules and report them to the IRS without a warrant. I think that's manifestly unconstitutional under the Fourth Amendment because it's a warrantless search and seizure of private information. And it's also unconstitutional under the First Amendment because as a charity, as a nonprofit, we are exercising our right to assembly and our donors are exercising their right to assembly, which includes a right to assemble anonymously or without government surveillance. This happened back during the Civil Rights Movement. The government of Alabama and Mississippi and some other southern states really wanted to know all the NAACP members in their state for the wrong reasons. And so the Supreme Court protected a right to private association, including charitable giving. And that's important. It's fundamental to America. So we're suing the IRS saying that the 6050I reporting rule, which forces us to identify to them all of our donors who pay in crypto and forces anybody being paid in crypto to surveil their counterparties without a warrant, is unconstitutional. That case is Carmen versus Yellen. We brought it under the last administration, but it's continuing into this administration. Carmen he's a Bitcoin miner, Dan Carmen. So he's a co-plaintiff of ours. We're another plaintiff in the action. So we're hoping that lawsuit goes well. That lawsuit will ultimately tee up these exact same issues of like, what are the limits of government mandated reporting for financial transactions with respect to the Fourth Amendment. Another way you challenge the BSA that, would occupy me for another 5 or 10 years, even after, hopefully these new laws pass. If we still had to fight overextension of the BSA, you can argue that the BSA is unconstitutional because it's a delegation of legislative power to the president without an intelligible principle, without some sort of clear limiting principle. And so this goes back to this notion in America that we have a separation of powers. Like Congress makes laws, the president just enforces them. The president and the executive agencies are not supposed to make up their own laws. They're not elected to do that. And the Bank Secrecy Act is this delegation of lawmaking authority where Congress said, you know what, we're not going to decide who is and is not a financial institution. You can figure that out. You can just, with the wave of your hand as an unelected official, suddenly obligate millions of people to do financial reporting that Congress never comprehended were necessarily going to be within this scheme, but gave you the authority to do.
Yeah.
So the non-delegation doctrine says that Congress isn't allowed to give its lawmaking authority to the president. And in a very real way, the Bank Secrecy Act, because it has these sweeping, discretionary powers, gave the Treasury lawmaking authority that they probably shouldn't have. So if they were to come for crypto in certain specific ways, like everyone's now a financial institution according to the BSA, or everyone, even ordinary citizens, need to report their transactions in a specific way for criminal investigations without a warrant, that's just manifestly unconstitutional under the Fourth Amendment, but also because the power you're doing it with is a legislative power and you're not the legislative branch.
Yeah, I feel that, or just from just a personal interest, and then swimming at the SED is that it just does feel like that the BSA is due for a redux, or just some kind of frontier there, and it feels and it's curious to me, just and also in its relation, just kind of the Coin Center mission, or in that it definitely feels broader, and it's I don't know if there's other.
So larger scale BSA reform, that is something we're starting to get more interested in. And not just bringing lawsuits to challenge the overextension of the BSA, but actually what are we going to do if we go to a member of Congress who's interested in financial privacy? Say they're already interested in Gramm-Leach-Bliley laws, which are how actual financial institutions are supposed to disclose certain information about how they collect your private information and share when they share it and who can they share it with. To me, the bigger problem from financial privacy is not what institutions can do with your information once they have it. That is a problem. We should buttress Gramm-Leach-Bliley and have better consumer protection laws for private information. The bigger problem is, how did that information get there in the first place? Why does JP Morgan have all of my transaction history going back to when I was 12? If they do, and they probably do in many cases. Like, that's the problem. And a big part of the reason why they have so much information is because they're mandated by law to collect all that information under the Bank Secrecy Act. And the reason why we've made this trade-off where we're basically forced to give up all our privacy to banks is because of money laundering. And yet even the United Nations and the Financial Action Task Force, so like respected NGOs in this space, say that AML KYC policies only really result in the seizure or blockage of about 1 or sub 1% of all illicit funds in the global economy. So this is like a dismal track record. We hand tons of information, very sensitive information, to banks. We're required to hand that information to banks. Banks are required to collect it. Banks then get hacked. Our private information ends up on dark markets, and Russian hackers use it to set up fake accounts in our name and launder money. And are we actually stopping money laundering by having all this private information collected about us and like our identities verified by financial institutions? Not really. Like, it's a very bad track record. So the whole system's quite broken fundamentally, and not just broken if you're like a civil libertarian who's like, I want to live in the mountains and people shouldn't know what I do, but also broken if you're worried about money laundering because it's not stopping money laundering. And so there's a very interesting conversation to be had over the next few years about like, can we do better than the Bank Secrecy Act in a way that both protects people's financial privacy but also deters money laundering? And are cryptocurrency technologies a part of that answer? Because they probably are. I'm scared sometimes to have this conversation because there's a dangerous version of this conversation, which is everyone should just use Bitcoin and not reuse the same address all the time. And everyone should have Chainalysis, and everyone should therefore know what everyone else's transactions are all the time. And no one should be allowed to use Samurai Wallet or confidential transactions or privacy tools. And then, yeah, we'll have perfect surveillance of the entire financial system via cryptocurrency. And that probably would deter more money laundering than our current approach. That's a bad use of our technology to effectively create a panopticon. There are, I think, a lot of promising things being done in the world of zero-knowledge proofs, secure multi-party compute, verifiable credentials, and like new blockchain-based identity aggregation, risk scoring type things that, if specified correctly, could allow you to selectively prove to JP Morgan Chase that you are not on the OFAC list, and therefore they should open an account for you without you needing to, for the 30th time, take a photocopy of your passport and send it to them. Like that would be a baby step towards something much better. Now we don't have all these honeypots of private data everywhere, and we're leveraging some of the cool tech in our space, like zero-knowledge proofs and such, to nonetheless provide robust verification of certain relevant facts about our identities to financial service providers, rather than just dumping all our personal documents on them all the time. So there's a path there. And it's a compelling path, both for people who care about financial privacy and for people who care about stopping money laundering. But there's a lot of landmines on that path as well, where we could accidentally, call for deeper surveillance of financial transactions using the very technology that we've developed to hopefully stymie over collection of data. But yeah, it's a big conversation.
Yeah, it does feel like the next frontier, though. So maybe we get through this section. Was there anything else in kind of important or relevant or like adjacent to these topics?
Yeah, I think one way to tie this back, we got into like novel forms of digital identity.
Yeah.
What does that have to do with self-hosted wallets? Actually, an F ton, a whole bunch. Because the only way we're going to have good user sovereign ID or a good digital identity of any kind is if we can carry our own credentials in a form that we truly control.
Yeah.
Like using public-private key pairs or, multi-party compute amongst ourselves and other and friends and family and things like that. And so the technology of self-custody, which grew up around people being able to hold their own cash, electronic cash, Bitcoin, also needs to grow up around securing the other things we keep in our physical wallets, which are our identity credentials. Because we could very easily right now end up in a world where, Google just holds all of your digital identity cards instead of you. And that's not a good world. We could end up in a world where the US government or your state government is basically the fiduciary for all of your digital credentials. And that's also not good. It should be the same self-hosted wallet tech that has been sort of born and flourished in the cryptocurrency space that's used as we move into a digital identity realm. And that's another reason why policymakers who might not care much about Bitcoin should care about self-custody, actually, because this architecture of like holding your own keys
Yes.
is the only way we're going to build a fair and just and a fair and just internet that protects our rights. If we don't have the ability to hold certain fundamental cryptographic primitives that control either our money or our identity or what we do online ourselves, then we're just going to rapidly see the expansion of corporate and or government power and the end to individual liberty, at least online. We'll just have to go live in the mountains. Back to your trip to Alaska.
Bring it back into the wilderness. Yeah, I think that makes a ton of sense, and that's why, just from being able to be in the industry over now, you're entering your second decade, but it's like you have to kind of then get to watch these ecosystems evolve, because I just do think Unchained is built on the backs of Ledger and Trezor. Those are main ways clients interface with us to produce signatures and authorize movement of their funds. So it is this kind of like frontier of just, as those get more adopted, as they're more convenient and usable, that it then can be used in this these not just money-based spheres, or not pure financial transactions.
Yep, 100%.
Cool. Well, thanks so much. Thanks for all the work you do, and
yeah, of course.
Yeah, how well you do it too.
Thanks, Joe. This was a pleasure. This was a great conversation.
Thanks, Peter.
Take care.